This case is big to a lot of different people, so I wanted to bring someone on who can give us somewhat of a legal perspective. Marcus has agreed to walk with me through this case and offer some of his legal analysis. Now, I do want to say we do not have all of the evidence, so a lot of this commentary is going to be based off of the information that we do have, and then we're going to speculate a little bit on how this can play out. So, Marcus, introduce yourself.
Hello, everybody. My name is Marcus Landsberg. I'm a criminal defense attorney. I passed the bar, give or take 20 years ago. I was practicing as a criminal defense attorney for that amount of time. Recently, about a year ago, I decided to take some time off to make sure, after COVID, I realized I like spending time with my kids. So we decided to take some time off. I've spent this time helping raise my children better than I could when I was at the office, 25 hours a day. For that reason, I now have a lot of free time where I want to still give legal advice. So I appreciate you giving me this opportunity to look at this case and talk about it, because I really hope he's not guilty. I hope no people in this case got abused. I hope no one got injured or got abused. And I never want anyone to be guilty in a situation like this. That being said, if something did happen, hopefully that what ends up coming out of the justice system is what's best for all parties involved. That being said, we all know with justice system, that's not always what happens. So.
Right, exactly. I want to walk through this in a chronological order of the news cycles, and I'll ask you questions as we go. So let's start. On Saturday around March 25th, 6 p.m. Eastern, TMZ drops the bombshell that Jonathan Majors has been arrested for, and I quote, strangulation, assault, and harassment. Later that day, it was reported that he was released without bail, and he was formally charged with misdemeanor assault, aggravated harassment, attempted assault, and harassment. First question, briefly, what are some examples of misdemeanor assault and attempted assault?
So I don't want to get into specific New York law because I never practiced in New York.
Mm-hmm.
Generally, in the model penal code, or which is what most laws come from, or in my jurisdiction, harassment is considered the lowest level. So harassment is usually, the intent has to be to harass, annoy, or alarm somebody, but not cause them pain. It doesn't have to be to hurt them, just to harass, annoy, or alarm them, and touch them in a manner intending offending conduct. Tapping someone on the shoulder may not be an issue. Touching them in another way, or if you tap them on the shoulder and you meant to be offensive and meant to harass them that way, it could still be against the law, for example. Any law that includes the phrase assault, and again, this is national, so it changes based on your jurisdiction, usually includes some element of pain. Now, pain can be defined in different ways in different states. You're going to hear me clarify everything as we go through this, right? It can be defined different ways in different states, but usually a complaint of pain or feeling pain, that's the accusation when it rises to the level of assault, which is usually, despite the name, a higher charge than harassment. That being said, part of the problem when you get to a jury is, do they believe the person really felt pain, or is the person just saying they felt pain? Now, there's usually some evidence of redness, bruising, injury, but there doesn't have to be for an assault type case. If the jury believes they were hurt, they were hurt. There doesn't need a breaking of skin or redness on the skin.
Can harassment also be verbal?
There is verbal harassment the same way. Usually that arises it has to be, they say, could you stop it? And you continue going. Because it has to be with the intent to harass, annoy, or alarm somebody. So whatever you're saying, you have to have that intent. And it's hard to show that intent unless they show you what you're doing is harassing, annoying, or alarming them. Does that make sense?
Got it.
Normally the definition of harassment is, like, they pushed me, but not to hurt me. Just like, they kept poking me, or they kept pushing me, or they kept trying to, the one where they push you until you hit them back, that kind of stuff. That's usually where it is. Now, when we talk about harassment and assault being in the same charge, usually those are two separate touchings in the same context. So the harassment would be the push, and not in this case in particular. The assault would be knocking somebody down, but the harassment would be maybe holding them without trying to physically hurt them after you knock them down, if that makes sense.
So the article states he was released without bail. Why would someone be released without bail for domestic violence? Is it because these are misdemeanors, or from your perspective, why did they let him go without a bail?
So my understanding, I don't want to get this wrong, but in my understanding, New York passed some sort of bail reform law. So
Right.
if it's a misdemeanor type case, he has to be released without bail.
All right. So third question. Originally, it was reported, this was the TMZ report, and I'm assuming the police report, that he strangled her. It seems like the strangulation accusation was never made to arraignment. Is that your assessment as well? I'm just confused on what happened with that strangulation accusation, because to me, in my brain, I'm not a lawyer, but it seems like that would be like a serious felony, but it seems like it never made it to arraignment.
When the prosecutor makes the final offer of charge, if they don't have the proof for strangulation and what the strangulation says, usually the law is there has to be some sort of stopping of the breath or some sort of inability to breathe. If you just have redness to the neck but no accusation of inability to breathe, you may not have evidence for strangulation, for example. So once it goes to the prosecutor either has to do well, this is a misdemeanor, so I suppose not. It sounds like what the prosecutor did is review whatever evidence was given to them by the police, and either the police or the prosecutor decided there just was not enough evidence for a strangulation charge, is my prediction based on what minimal evidence we have here at this situation.
What happens during an arraignment? Because based off of how this was wrote up, it seems like he went in like 11 o'clock, 12 o'clock in the morning after he called the police. Seems like he was let out within maybe 5 to 6 hours. What happens during an arraignment? What is that?
So an arraignment is the initial court charging of the case. The whole purpose of the arraignment is that your charges are public. But that arraignment is the formal decision of what the charges are. That's all an arraignment is really supposed to be.
Got it. Okay. Jonathan Majors is in jail. I'm pretty sure he calls his manager or somebody. They get his PR people on the line. PR people calls Marcus. Marcus, Jonathan Majors is in jail. He's accused of assault. We need you to go up there. We need you to get him out. Once he's out, what is the conversation between you and Jonathan Majors?
So for me, at this stage, before anything becomes, what I've probably done is talk to the detective, said, hey man, off the record. What? Like, look, don't tell me anything you're not allowed to tell me. I'm not trying to ask for anything. But I want to make this go smooth for you. I want to make it go smooth for him. Just tell me what's going on. It's going to be public. I'm getting your report. Just and sometimes they'll say, I'm not telling you.
Mm-hmm.
Usually what they'll do is tell you, and sometimes they'll give you sometimes you'll get a detective who gives you a fair assessment of, I don't know what this is, or usually they'll tell you what they haven't checked up on, things like that.
Mm-hmm.
They always think your client is guilty because they wouldn't arrest him otherwise. So I'm not saying what they're going to do, but sometimes you get some insight. So I get that information. I make sure he hasn't given a statement yet, because that's, to me, rule number one. Now, there's exceptions, and I understand in this case maybe, but there's exceptions. But I want to know what statement he never gave.
So when you say give a statement, is a statement considered him calling the police, or is a statement considered when the police gets there, him telling what happened, or is it a statement when they sit you down in the room and say, hey, what happened? Or is all of that, of course, can be used against you?
So the answer is yes to everything you just said. When I say I want to make sure you didn't give a statement, what I'm talking about is really sit down in the room and talk to them. But my next question right after that is, okay, but you told them something. What did you tell them? Right? When they said, don't worry, just tell me off the record, what did you tell them? Is there going to be a phone call that comes up? Any of those things, anything that you said, did you send anyone a text message that's going to come up later? I need to get into that information. That's what I want to hear. Now, the truth is, I want to start from the official statement, meaning the one you sat down and had either an audio recording or you signed. That's what I'm most worried about, but all the others I'm just as worried about. The difference is on a microscopic scale. So you're correct when you say, which statement are you worried about? My initial impression is I want to make sure he doesn't give a statement, is I don't want him to go back and say anything. And then I need to know, does he think they're getting back together again?
Why is that important?
In a case like this, which is an abuse type case, this is a little bit different because there may be witnesses in a case that may have happened, right? Like, it sounds like there's two different situations they're talking about. I don't know if I'm jumping ahead, but it sounds like there may be something that happened at the apartment, but also something that had happened in the street in the car. And it sounds like they want to each talk about something different. Does that make sense?
It makes perfect sense to me. That's what I've been saying the whole time. It seems like his lawyer is like, look over here. We're not hearing from the DA, but I think the DA might be like, we're looking right here.
In any case which doesn't have a very specific eyewitness saying, I saw him do this, even then, you really need you don't always need, but you generally need the complaining witness to come talk. Now, obviously, you don't always need a complaining witness because you don't have a complaining witness in the murder case and people get charged for murder all the time.
Mm-hmm.
That being said, you generally need a complaining witness.
And when you say complaining witness, you're saying the victim.
I've been trained to say complaining witness.
Okay, you're a defense attorney. Got it. Okay. Mr. Jabarri, he would need
Mr.
Jabarri to
correct.
come and speak.
So generally the prosecution would want Mr. Jabarri to come say, he's the one who did this. I did not start. I did not set him off in any way. I didn't start it. I didn't touch him first. Not that that's the legal standard, but they would want her to come say something like that. He did these things to me. They caused me pain. I felt harassed, annoyed, or alarmed. And I got injured because of it. Whatever injury hurt, whatever the standard is. That's their best evidence by far. Talk about the Tory Lanez case. Some people would say he was convicted only based on what Meg Thee Stallion said. She got on the stand. She said what she said. I got bullets in my foot. This is what happened. Here's what happened. They didn't need any other evidence. Now, they used other evidence, but they didn't need that. If a jury believed her, that was enough. And a prosecution always wants to go with that if that's what they have. Now, if she stays in Europe, if she stays in another state, if she doesn't come to court or isn't able to be subpoenaed to come to court, generally it's very hard for them to prosecute him for a case like that.
Why would it be hard to prosecute, especially in domestic violence cases? You always have the victim who, like you said, I may be getting back with him. Maybe I don't want to prosecute. Why would, I guess, the DA or the prosecution feel like it's hard to do this without her cooperation? Because like we said, she's in Europe.
We don't know what she said or did or touched him at the beginning of the fight. We don't know how he's injured or what he had to do. We don't know if she leaned over and whispered, I'm about to kill myself when I jump out of this car. You're breaking up for me for a movie star? I can't, what am I going to do? Like, I give him my best years, whatever she says. Like, we don't know any of these things. And if that makes him hold her, put her back in the car, and I understand that's different than what's being complained, and I understand I'm talking as a defense attorney, I'm not trying to trigger anyone.
Mm-hmm. Right.
But if that's the way she described, some of the things she described was he grabbed her, he held her, he put her back into the car. Mm-hmm. I've had similar cases, not with movie stars, right? I had one case in particular where the woman who gave the statement, in her written statement, the prosecutors needed to protect her. She got on the stand and said she punched the defendant in the face first. That wasn't in any written statement. It wasn't in the defendant's statement. Prosecutor said, did he hit you? And she said, yes. And I forget if I asked or she or the prosecutor asked. They said, what happened right before that? I punched her in the face. What?
Yeah, it happened. We saw it, like you said, we saw that with Tory. The prosecutor had Kelsey as the star witness, and she's going to get up here and tell it all, and she gets up there like, I don't remember.
So that's the kind of thing. And if you don't have that written statement, or you don't have that audio statement, or you don't have an excuse to get it in because the defense attorney gives you an excuse to get it in, not to go too much into another case, you have somebody who said it never happened. Now, you can play a video of it, but they don't tell you what the conversation was before. They don't tell you what the conversation was the night before. And I'm not saying any of that is an excuse for it, but you really need to. And then the other thing is in the case where, and I again, getting ahead, if there's video where supposedly she broke her finger, and then the video shows her using her finger, or the bartender saying her finger was fine, things of this nature, you really need her to say when that happened. Right. So it would be very hard to prosecute without her to say this is when that happened, if you then have subsequent evidence where very clearly, I don't know that it's that clear, but arguably, very clearly says that's not when it happened.
So we're going to rewind. We're going to go back to, you've just finished talking to him. He's walking out. Y'all have talked. His lawyer immediately came out and said he's innocent, which is what the lawyer's supposed to do. She said, we have video, we have written statements, and the victim is recanting. 5 days later, we get text messages from the victim. As a defense attorney, tell us why those text messages was released to the public. Why did she feel the need to give that to us?
So this is what I think is important to remember. He is not trying the case to be not guilty in court at this stage and early, because the smart play is to shut up, you sit on it, and in court, or the latest possible, you surprise. Sometimes you can't surprise the prosecutor. In my jurisdiction, you have to turn over evidence like that early. but you wait until you get all the information from the other side. You turn over your information, and then the jury, who's now expecting this vicious, horrible, gigantic guy who beat the hell out of Michael B. Jordan, right? Who's going to hit this poor skinny woman. And then they hear this other side of the case. If it doesn't match their mental image of their movie they made in their head, they can't believe that it happened. Does that make sense?
Right.
So that would be for most cases. But in this case, and I think it's very clear, he's fighting to save his part in the Marvel movie. Like, I don't think it's unfair to. I like to talk about the elephant that's in the room.
Right.
This is not your everyday criminal defense case. And it sure seems to me at this stage, this is a case where the PR team may be running the case. But I think what's important is that the defense attorney has their hand on the handbrake. There's a lot of people, and I want to tell you this. I released a video before this stuff came out that you guys got to hold on. They said
I watched it.
They said this was in a taxi. You're going to have a taxi driver. Most taxis in New York have some kind of camera in them. Now, since that time, it stopped being a taxi. It started being like, I think they said a private
Black
car
service. Mm-hmm.
So it's not like a Uber or a, yellow cab. So it may not have a video camera the same way, but it sounds like there might have been. I said, watch for that. And I said, watch for the text messages. I told you guys in that video. I said, there's going to be text messages after an event like this. If there's a breakup in the street and they go their separate ways, before the morning, one side or the other, if not both, are sending 40, 50, 60, 70,000 text messages. It's the nature of the beast. That's what happens in situations like this.
When you look at these messages from, which is only a portion, we can't see everything.
Right.
What is your impression of these texts, of these messages from Grace? Because it's mostly from Grace. The lawyer obviously cropped out the parts that Jonathan sent. We only have 2 things from Jonathan. So what's your takeaway from these messages?
This is not a text message that says, I lied. A person who works in domestic violence would read this text message and say that she's a victim of domestic violence. And I can't say it any clearer than that.
I don't work in domestic violence, but when I seen the messages, I'm like, this does not look good. Why did his lawyer release this? And I think you just answered it. We have a man trying to fight for his movie career, so I think we understand why she did it, but to the general public, everybody's like, this is not what we thought was coming.
I can't reach into that lawyer's head, but I will tell you what these are most likely are real text messages. This is not manufactured text messages. This is not something where he or the lawyer suggested to her, could you text him this so you could release it?
Of course.
Right? Now, when I read her statement, for example, it says, they just called to check on me and I reiterated how this was not an attack and they do not have my blessing on charges being placed. If she just said, I shouldn't have lied to them that this was not an attack, that would be great. But what she's focused on are the charges. And anytime they're focused on that, the problem is it doesn't hold a lot of weight when you show it to the jury in that kind of sense. And people get the same impression you get. What you can take from this is someone who's trying to stay with her. She at this point had not sailed as far as she wants out of the relationship. Does that make sense?
Right.
And what I told you, one of the first questions I asked is, are you going to stay together in this?
Right.
That question changes on a daily, if not an hourly or a minute-by-minute basis in any relationship, even once you're married. Right? We're not publishing this all the time, and I'm not saying this is a misstep, but I don't think this was the smoking gun that had never happened that we were supposed to be sold on. And the one biggest mistake you can make as a defense attorney or as an attorney, I think, is overselling your case. When you oversell your case and you don't meet, well, let me put it in movie terms. If they tell you this is the greatest movie that's going to break the internet,
right?
And then you get The Flash, doesn't do super well. Right. Now, when you don't know the movie's going to be amazing and then it is, that's the one everyone talks about and goes around the world. And a case is no different. It's just closer to a documentary than it is a superhero movie.
Got it. Okay. So we fast forward about a month later, April 19th, we get video stills from, and this is the second club. The way this was presented to us is there was a altercation or maybe the start of an altercation in bar 1. They get in the car, they separate, she goes to bar 2. So April 19th, we get video stills from bar 2 where Miss Grace was attending. There's videos of her using her injured hand. And I felt like the lawyer releasing these without context was a horrible move because it read like, look, she's partying. There's no way she's injured. Versus, it seems like now she's trying to clarify, like, we released these stills to show you guys that if her finger was injured or broken, she wouldn't be able to hold her phone. She wouldn't be able to hold drinks. Why do you think at the time the defense released these stills without context? Because it didn't come with context at the time.
Oh, it goes to show that she's partying. I mean, those are the reasons. I can't imagine it wasn't. If she partied after she got injured, you have a club full of people who didn't see her injured. If she's not tore up in the evening the way she's tore up in the morning, it could easily be because she drank too much, or something else happened, or she forgot what happened. Anybody who testifies, anybody in a court, has to have both memory and perception. You have to be able to perceive what's going on. Alcohol interferes with that. And you have to have the memory of what happened in order to relate it to people in the jury, tell the police, tell the prosecutor. So if they're showing her partying to say that maybe she didn't get the exact story to get the whole story, the figure may be an after the fact justification or an also told.
In your opinion, originally, you're thinking she released this to show people that she's partying. There's other people around who can see she's partying. So by the time she gets home, maybe her memory isn't as clear. Maybe things are a little blurry. That's what you're thinking.
I know if I had a jury who had seen pictures of the person partying after whatever the incident is, the reason for that is to show that the person is not affected by whatever the last incident was, that it was not the end of the world the way they're saying it was.
Is it fair to say people that are in domestic violence relationships, sometimes things can become normalized? So is it fair
Absolutely.
for the prosecution to say, well, that doesn't mean nothing. Maybe she went to the club to drink off the pain. Maybe she went to the club to let some steam out.
100% I agree with that. I also agree that people react to different events in different ways. There's no perfect victim is the old phrase prosecutors like to trot out. And there isn't. Like a lot of people, God forbid, get injured in a situation like this, and you have to drink to make the pain go away because you don't want to go to the police. That's a painkiller. Like you go somewhere else and someone gives you, it's like, so there's all those things going on. But the reason you do release that, one, is not everyone sees the world that way. The other thing is you have a club full of people who are not seeing her injured, buying her shots, looking like she's having a good time, right? Originally, didn't they report that she had a laceration on her neck?
Yes, it was reported that there was a laceration behind the ear and redness around her neck. I think that's where the strangulation came in, but it was kind of tossed out. But laceration behind the ear and a broken finger.
So you have at least one club full of people who either saw her with it, saw her without it.
All right, so now we jump over to May 9th, and this document looks like maybe a witness statement. I'm not sure what we call it. But there's some key things in this document. I don't know if you have it. I can probably resend it. But can you explain to us what this document is and what could be the reason why it seems like she's cooperating now versus before a month earlier in the text message?
What this looks like to me is it looks like a factual basis which they're using as a means for a charge. But what they want to see is, one, all the elements of the charges accused. That's why you have that first paragraph on the first page that has that weird list of all the elements. And then below that, you have the factual basis, which goes on the second page, which is a bare bones, super skeleton accusation of what happened in the case. I would suggest in a case like this, there's probably an oral or recorded statement, whether it's to the police officer or the prosecutor or both. We know she's given multiple statements.
Right.
So there's a potential that there may be other written statements that she has, provided the prosecutor say things like that never happened or that's a big misunderstanding.
Why do you think, because this document is signed as of May, so it's about 2 months later, why do you think there has been a change of heart from the text message where it was, hey, I let him know, this was my fault, Is it that maybe when those texts went out, she was trying to protect him in the relationship, and now 2 months later, she's like, okay, now I'm ready to talk?
Yes.
Is
Yes. I mean, generously, it could be that she's finally realized it's time for her to come forward and get something done to save, the next person from being hurt and really help him move forward in society. And more cynically, it could be because she sees him dating Megan Good. Like it.
And that was my next point, because this is dated May 9th. May 13th, 4 days later, it hits the blogs. Jonathan Majors is with Megan Good. I think we know this is PR. I'm not going to say that their relationship is fake. The relationship could be real. I just find it odd that this document is dated the 9th. I don't know if this was a document sent over to his lawyer. I don't know.
My understanding is the current reports is maybe the argument in the vehicle had something to do with the knowledge that he was spending time with Megan Good. I don't think that's impossible to predict. I also think even if it's not her, it could be someone else. It could be that his star's on the rise. He's looking for. So
I found it interesting. May 9th, that document is signed. May 13th, it's public. And one thing, like culturally, like I followed Jonathan Majors for a couple years. He's not really a public person with his relationships. I think there's maybe 1 or 2 pictures of him and Grace. Megan Good has never really been public with her relationships either, except when she was married.
Right.
Before she was married, you've never really seen her just dating out like public. So I always thought this was a very weird public relationship because they both seem very private outside of when she was with the preacher.
Do you think this is a fake relationship? Honestly.
I think the relationship is real, but I think the publicity of it is forced. Jonathan Majors does not give me the energy that he wants. He doesn't even have social media. He doesn't give me the energy that he wants this relationship to be public. When I first seen it, I'm like,
I am going to tell you something that you don't need to hear, is that I think Black women are probably the most loyal as far as supporting people when people are on their side. And I don't see any reason why Megan Good would get into a fake relationship. Like, why would she sign up for this problem if it was real? I think it's not beyond many Black Americans who are accused of a crime, men, to get into a relationship with a high-profile Black woman or all of a sudden get back into the Black community and find amazing support. You go to Tory Lanez, and there's Black women who support him over and above Meg Thee Stallion, like to the point where they have amazing, wild stories of, magic bullets and what could happen. I don't mean to go back 30 years, but the best example is always O.J. Simpson.
Right.
How the Black community came together in favor in his support. You go back to the safety of home, maybe. If he can get Black women to support him, then that's a rock solid community.
Right.
I'm not saying they won't do what's fair, won't do what's just, or won't do what's true, but they may be predisposed to listen to, she's mad that he's now trying to.
Mm-hmm.
I mean, there's the race and sex and movie stars. A lot of that stuff gets involved, and
right.
It's difficult to talk about.
Right.
But we have to be honest about it. And if we're trying to fight for a man's life, as his defense attorney, I'm trying to fight for his life. Got to be honest about it. I got to tell him.
Right. So if because you're defense, you're not PR.
Right.
If you're his lawyer, are you involved in those PR meetings where they're saying, hey, we know you're dating Megan. Like, we're going to send paparazzi out to...
As an attorney, I'm telling him, number one, don't do anything fake. Don't do anything that's a fraud.
Mm-hmm.
It's easy to smell a lie. I don't care how good an actor you are. It'll come back to bite you. Even if you're an A-list actor, or should be, even if you're, right, Lovecraft Country is amazing. Even if that's who you are, it's going to come back to bite you if you start lying. So don't do any of that.
Exactly.
Right? But you don't say anything, then you lie. That being said, and I would also tell him, don't enjoy yourself too much in public.
Exactly.
You should be punished for this. Even if you're not guilty, you shouldn't be having a good time being around somebody who's having that bad a time. I don't want you to be putting in her face how much fun you're having.
Exactly.
That being said, you're a real person. You're allowed to do real person stuff. And if that means you guys go enjoy your stardom, like I probably want to go to the beach, but if what you guys do is eat around New York, right? I just don't know why Megan Good would get into a fake relationship. Like, it doesn't seem like
Right.
that. Like, I don't know how to help her.
Yeah. I don't think it's fake. I just think it's weird publicity. Okay, so we've jumped past that. All right, so we jump forward a month later, June 20th, first in-person court appearance. What is your idea of what happened during this first in-person court appearance? What happens when he walks in?
It sure looks like what they're doing in this case is racing to try and go to trial as soon as possible in order to get that done. So sounds like all that was they had got together and said, can we do it a trial this week? In a case like this, it would not be rare. Well, okay, in a misdemeanor case, it is not rare for them to go to trial quickly. Although with a jury, sometimes it extends it out longer. I don't know if this is supposed to be a jury trial or not. He has a right to a jury, most likely if it's a Class A misdemeanor. Rushing a trial is never your first strategy, but it doesn't mean it's always a bad strategy. It only happens if there's outside factors which are coming to play on your case. It's not uncommon, but it's definitely not common. Jonathan Majors, my understanding, is trying to race this to trial as soon as possible. He does not want to delay this. He has to win this case or be exonerated to some degree before they start filming. I think it's Kang, maybe Loki, but I think it's Kang. The whatever the next movie.
Loki's filmed. They announced he will be in Loki, so Loki's been done for a year.
Yeah, but
it's wrapped.
I wouldn't be surprised if they don't have two endings for that.
Yeah, they do. I'm sure they do.
I wouldn't be surprised if they have the ending where he stays Kang and the ending where Kang take his mask off.
I'm sure there's two endings. I'm 1,000% sure.
So if that's what's going on, right, then he needs to win before the end of that so they know which ending to use.
Right.
And Disney is not required to abide by a judge's decision, not in any means. But I think that's the ultimate goal. So,
okay. So we're going to hit the Insider article. This is where this article came out exactly after he walked out of the courtroom. So I'm just going to skim the article. It says, during this meeting, the lawyer pretty much says the driver is ready to testify. There's video footage from the street and inside the car. It was described as her attacking him in the car, asking the driver to pull over. He tries to run. She grabs him, pulls him back in, rips his coat. He gets away. He runs. He goes to a hotel. She goes to a party. She's freely using her hand. He texts her and says it's over, powers his phone off. She leaves the bar, sends him suicide messages, goes to his place, takes a bunch of sleeping pills, locks herself in the closet, passes out. He wakes up the next day. He sees the text, runs home, gets a locksmith to open the closet. He calls 911. Hey, my girlfriend's in the closet. She's passed out. We need help. Police show up, separate them. What is your thought process about all of that? Mind you, this is all coming from his lawyer. So we don't know what the DA or the prosecution has, but all of that put together, which is basically the story his lawyer is trying to tell. What are your thoughts about all of this?
So, generally, I don't like him making a statement about what happened. You're a defendant. You don't have to. I don't want you to. Now, there's exceptions to it. This may be one of the exceptions. Because
think about it. You get home. Well, your girlfriend's text you. You don't want me no more. I'm done. I'm gonna kill myself. You run home. You can't get in the door. Door's locked. You see she's passed out. I think it's natural to be like 911.
So
my girlfriend's passed out. It's reported they got video footage of her.
How do you know his girlfriend was passed out in the closet?
So walk with me. She's in the club.
Right.
He texts her. It's over. I don't want to do this anymore.
So that's the text that we read.
Part of it. We didn't see the rest.
Goodbye, blank. You leave the key for me.
It said the lawyer's saying he powers the phone off. He goes to bed. As he's powering the phone off, they have footage of her reading the text message. She's sending him text. Pick up, pick up, pick up. They have footage of her walking through the lobby of his penthouse.
When they released the text that they did release, why didn't they release those texts? Because of the text that they did release, right? Those texts should have been there. They're not there. So it's possible that he deleted them, but I don't know how he went back and found them later anyway. If he deleted them so they wouldn't publish it, one, that may be tampering, but they should have been there anyway. So,
well, she probably still has. But that his lawyer is saying she sent him suicide messages. There's footage of her going through the lobby, finger's not injured. She's pushing the elevator door. She's going up. I don't know if he has surveillance in his home, but when he wakes up the next morning, he sees the text, the calls. He runs home. There's footage of him coming home. He tries to get in the closet. He can't get in the closet. He has to call a locksmith. She says the locksmith is testifying. Locksmith opens the door. She's laying on the floor, passed out. He calls 911. Hey, I need help. My girlfriend's in the closet, passed out. I need help. Right. And that's when the police get here.
So,
separation.
Nothing about that tells me that he didn't beat her up right outside a car the night before. Nothing about that tells me that. I'm not saying none of that happened or that.
Of course.
But if we're talking about rebuking whatever happened the night before, now she then made the complaint to the police subsequent to that. Is that what happened?
No. This is the story. Police get there. She's taking a bunch of sleeping pills. So by the
police get there, they ask her what happened, and she says the night before he did this.
She says, "What's wrong with my finger?" And I think that's why the lawyers are using all of this. She wasn't injured coming into the home. They have footage. She's pushing the button on the elevator. The lawyer's trying to insinuate when she got in the home, she passes out in the closet. And when the police get there and wake her up, they said the first thing she says is, "What happened to my finger?" And that's when the police are like, "What happened to your finger?" And she's like, "I don't know. I can't remember. Did he do this to you? We got into a fight, but I can't remember. Blood behind the ear."
Yeah, I got into a fight. That's enough. We got into a fight is enough if she has blood. That's for a police officer to arrest. That's the problem.
So I think this is why all of this is kind of tying into the club footage. I think the lawyer's trying to say there's no injured finger here. There's no blood here. She's partying. She's walking through the building. She's pushing the elevator button. But when the police get here, we have a broken finger.
Well,
we have blood. We have redness.
Let's be clear. If the finger was actually broken, this would be a felony.
Okay.
A broken bone, I can't imagine when. I haven't read the law. Broken bone is usually a felony.
Mm-hmm. I think that's why all of this was released to Insider because, like we both said, I feel like the lawyer's trying to say, look over here. My brain is going to what happened from the first bar to the car. Because this could be the lawyer playing on words. She says her finger is not broken and her ear is not lacerated. Let me go back up to the first mention of broken finger.
Yeah, the ear laceration to me seems like if you're bleeding from your ear, especially if it's at all, I feel like someone at the club would point that out. And she's clearly there with a friend.
Well, this is the other kicker. They said when they're fighting in the car, he gets out the car, he runs. The people who are eyewitnesses, he takes a selfie with and he goes about his business. She ends up meeting up with those folks and they party together.
Wait, the ones he took a selfie with? Wait,
so
she parties with the selfie friends?
This is all in the Insider article. And like I said, this is from the lawyer's point of view now. I'm not saying this is the truth because, of course, she's going to, she got to do for her client.
No, I mean, you could shade it, but you can't lie about it, right? At least not and keep your career. You start lying about things like that in the press, you get in trouble. And you get in real trouble with judges to just say, how can I believe you now? You've lost your career, basically.
Yeah.
So
his lawyer is spinning it like she hurt herself in that closet. That is my impression of how his lawyer is trying to spin it.
And that's the purpose of having them go to a party earlier and having her go to a party later and release pictures of her at a very busy club. The real problem with that defense is you have to be very clear in a situation like this is what is a defense and what is a motive. And when you're publicizing something as a motive, especially something as a defense and it ends up being a motive, that's when you start to get in trouble for your client. The more she overreacts subsequent to the breakup may actually work against him as far as whatever the fight is outside the car. And that's what I would be worried about as far as overemphasizing, look at all these things that happened later, is that, yeah, because look what he did. He finally crossed a particular line that was uncrossable. And in response, she did something that was sort of uncrossable. She crossed a bridge she never should have done. But it's not a defense to abuse that the person you hit then went and tried to hurt themselves. And to a lot of people, it would be the opposite. And so I'm a little bit worried that might be the wrong message. I have no doubt if he did call a locksmith, I have no doubt the locksmith will come. If there is video in the lobby, stuff of that nature, I have no doubt that kind of thing. But does any of that mean that he didn't hit her or push her around outside the car? Because if she wanted to release a written statement from the locksmith, she could have. If she wanted to release a written statement from the downstairs security guy when she came home, she could have, or the bartender. If those things exist, she could have. But I'm not saying they might not have written it down. And honestly, as a defense attorney, you don't want them to write it down generally. You want it to be, if you trust a person to keep the same statement, you don't want it written down as a defense attorney. If you don't trust them to keep the same statement, a la Kelsey Harris, they can get that recorded. You follow me?
Right.
So
something is just telling me that something happened from bar 1 to car. That's what my gut is saying. Because the rumor is they're in the bar. She reaches for the phone. No, move, get out the way. Let me call the car. From bar to car, I wonder if something happened because his lawyer is only focusing on car to get home.
No, you're absolutely right. You're absolutely right. So this is what's going on. You're making a very good distinction, a very intelligent distinction as far as what the defense attorney seems to be doing is focusing on the reporting, what she did subsequent to the event, meaning like, is she still in the same condition? Is she in the same situation that she should have been had she reported to me, that kind of thing, until later. And again, none of that changes if she does say this is what happened in the car. If the jury believes her, that's what happened. Now, they do have the guy who's in the car. If they have a video from the cab the black car service, if they have a video of them starting the fight there at that point, that's the whole case. There's no reason to talk about anything else. And the fact that we're talking about anything else tells me that video does not show what that lawyer thinks they wanted to show.
So I guess with all of this, from your point of view, because from our point of view, the lawyer's like, we have all this evidence. Why do you think this hasn't been dropped? Is it obvious that the prosecution has something more damning? Is it possible that, well, it's obviously possible that his lawyer is saying, we have video footage of him running and she's pulling him in the car. Is it possible that the prosecution has other footage of the fight before the second half of the fight? Maybe he did push her in the car or pick her up and put her in the car.
All that is possible. Tory Lanez lost because one person testified credibly that he did what he did. Right? It doesn't matter what else happened after that. The jury believed Meg when she said what she said. And the prosecutor's job is to some degree believe who they've declared as the victim. They've declared she's the victim. He's the one who got arrested. The police did a full investigation and decided he's the one who was the person who did it. They don't just drop a case to drop a case. Like, it's not just because the lawyer says a lot of stuff, they drop a case. It's just their job is to defend or to protect the so-called victim. She is not protected if no one listens to her. They're her last defense.
Right.
This is what they signed up to do. The prosecutors took a pay cut in the sense of they're not working $300, $500 an hour jobs as lawyers to be prosecutors, right? Because they think they're doing the right thing. And the right thing is to protect people who are complaining of abuse. Even if they change their mind, because the person who changes their mind after they're being abused is setting themselves up to be abused again. Those are the people who need the most of it.
Exactly. And another reason why I'm just kind of at pause, because like we talked about, he went and filed charges. So if there's proof that she was fighting him as well, is the DA or the prosecution like, well, we don't care about what happened on the back end. You started it on the front end.
In my experience, they don't. Now, but you never want to stop someone from calling the police, but what you want to do is have police be able to investigate. It sounds to some degree like, I don't know that he's admitted yet that he has, but it sounds to some degree like these are two separate events that happen in short time to each other, right?
This is what he did admit, because when you sent me a message and said, hey, I've never seen this before, where he went and pressed charges against
so
her.
I did research on that. It turns out that's not uncommon in New York. In my jurisdiction, it's completely uncommon. And it's, I want to say, almost unheard of. A Prosecutor picks a horse, they ride that horse till the end. And they don't charge mutual abuse. The theory currently is that there's no such thing as mutual abuse. There's abuse in response to abuse, right? That's what abuse advocates usually are arguing nowadays. There's no such thing as mutual abuse. One's the abuser, the other is the person responding to abuse through some sort of self-defense, right? Usually the prosecutor chooses who they think is guilty, and it's usually honestly a race to, in my jurisdiction, it's a race to report. Whoever reports first, they're the ones who make the statement. But the police officer, the detective is, so now you're arrested already before you ever get to make a statement. Now you're giving the detective saying, I didn't do this, she hit me. And you can imagine how much credibility that happens in that sort of situation at that point at that time. So at that point, the ship's already sailed.
Is this line here, could this be assault? This is what he told the police. I was worried she would be hurt by traffic, so I physically picked her up and put her in the car.
It's very specifically why they told him he has to say, this is the reason I did that. Justification is when you're allowed to use physical force on or towards another person. You can use it in self-defense in certain categories. You can use it in defense of others. If they're attacking someone else and you meet these elements or these prior criteria, you can use it in defense of others. You can use it in defense of property in certain situations. And we all know different states, especially in the South, they have different levels of defense for different types of property, right? But that's what you can use in certain situations. Or you can use it to defend the person you're using it on if they're about to commit a crime or do something that may hurt themselves. So what's he saying in that statement? I thought she was going to jump into traffic, so I picked her up and put her back in the car. I've actually run that exact defense, believe it or not. So that is something you're absolutely allowed to do. Now, the jury would have to believe, and there's certain elements, and we can get into it if you want, but they would have to believe honestly that that's what you honestly believed and that that was a reasonable belief at the time. Also, that you used the right amount of force.
So it's came out that he's had prior aggressive behavior. He has an ex-girlfriend that he was emotionally abusive to. He has an ex-girlfriend that he was possibly physically abusive to. With these women being under NDA, is it possible that they can still testify, or does the NDA pretty much state that you can't? How does these past girlfriends play a part in this?
An NDA doesn't stop you from testifying under subpoena or under oath. That's a civil agreement that you make with somebody. Now, to be under NDA, you have to choose to sign that. That's not no one can force you to sign an NDA. Now, granted, they're going to use coercion in any way they can. That's the purpose of getting it. But can they come testify in court? This is the question. For a defendant, you're not allowed to use character evidence against that defendant unless he tries to put on character evidence that he is of the opposite nature. If you're just mean, right, and you're mean in this particular situation and they want to say he's mean, they can't use that as character evidence unless he says, or another witness that he calls, says about him, that the evidence has to be brought out by his attorney or by his side, not by the other side, says that he's nice. And then in response to him being nice, then you could rebut that with character evidence that he's mean. Now, you can do that for other people in the court, but you can't do it for a criminal defendant.
When you're defending people in these types of cases, is it normal for the prosecution to maybe bring people on to say he's a mean guy?
So
do you see that happening in this case? Like maybe they find some people to say, yeah, he's kind of.
So the only way they could do that is if he gets up and say, I'm not an aggressive person.
But how would they know that, ahead of time that he's going to get up there and say that?
So they got to keep him in their pocket. His reputation for some of these schools that like Yale and these other places.
Mm-hmm.
The big issue with some of this, one, what is emotionally abusive really mean when you're between, 18 and 23? Who knows what that, right? My understanding is the one girl who's actually standing behind him is his girlfriend from 13 to 18. So the girl from 13 to 18 is the one who said, nope, I've never seen him do that. I've never seen him, right? He never acted like that at all. The other girls, they put out statements from them without them okaying it.
Without their
There's some interesting things about that. But the hard thing is you can't really defend yourself from accusations of character. There's no way to do it. Mm-hmm. And if you see the accusations about Yale, for example, it's he was big, he was imposing.
Well, see, and that's why it's interesting to me. he was not a big guy.
Let's keep in mind these are Yale kids. These are Yale acting.
You're right.
Yale kids. These are Yale drama kids. So these are the best drama kids from around the world. The best, like the top, right? There's 2 or 3 schools to take them. Yale's one of them. You know, Tommy Lee Jones, right? He's Yale drama kid. I think, no, wait, he was Harvard. I'm sorry. But that kind of kid, right? And they use these phrases which, do you need me to say it? I mean, are racially coded.
That's what I was just going to get at. I'm like, these seem very definitely racially coded, because when I look at him as a kid, $135, he's not 210 like he is now.
You got to be blind to not notice he's relatively dark skinned. He's got African American features,
Afrocentric features.
That scares people, and it scares people who don't have access to that, who come from upper crust homes, who played in drama classes where didn't have
a lot of diversity.
So then when he goes to Yale, this might be their first time.
That's what I'm saying. Like when he's in Yale with them, he's one of 3, 1 of 5, 1 of 10, maybe.
So now he probably played every single role of imposing person. That was probably his role when they did drama works. Hey, we did an imposing person. Hey, I know a guy, right? Hey, I don't know if that's part of how he got to where he is or part of what's demanded.
Right.
Is it demanded that you, and like, you know, we've heard the tapes of Christian Bale, for example, yell at people. Right. That's generally not acceptable, but because we're asking him to take his emotions to a certain role, to a certain place, is he allowed to do that?
Something like this. How long do you think this trial is going to go on with these misdemeanor charges? Tory Lanez and Meg went for 2 weeks.
I mean, if it was anybody else, it'd be a day and a half, right? Maybe 4 days. Maybe 4 days.
What do you think's going to happen?
You know, you can never predict the future of a situation like this. I hope he's innocent because I really want to see him in these movies, and I hope she never got hurt. I really hope she was not injured in anything like this. Like I really do. And I hope they both get the help they need going forward, because guilty or not, right? Guilty or not, it's clearly a problem.
All right. So final predictions is we're going to wait it out. We're going to keep our ear to the ground. Marcus, I thank you for all the wisdom that you have bestowed upon us. Any final words? Anything you want to say?
I appreciate anyone who's willing to listen to me for that long. So thank you for having me on your show.
We're going to follow, maybe me and Marcus will meet back up when some more stuff come out. Maybe we can run into this again.
And if you have any questions, let me know. Like if there's other questions, go ahead and send them in.
Yes. If y'all have questions, go in the comments. Follow Marcus. I'm going to put all Marcus's tags after this video, so y'all follow him. All right, Marcus, thank you.